Carletta is our next person. Carletta emailed us a question, and it simply goes like this. I slipped and fell in a store. I went to the doctor, and I have an aggravated disc in my back. I haven't been able to work because I've been going through physical therapy. When the store's insurance man contacted me, he told me that they would not be liable, but I'm stuck with a bunch of hospital bills and doctor bills, and I don't know what to do. So what should Carletta do?
That's pretty simple, wouldn't you think, Marty?
Yeah, I think, fortunately for Carlita, the store manager doesn't get to make that determination. I mean, that would ultimately be up for a jury to determine whether the store was liable. And I mean, premises cases in Georgia are difficult. I mean, she would have to prove that there was something that the store did wrong or didn't remove or knew about or should have known about that she didn't have some knowledge of that made her have this fall. But if that is the case, then the store may very well be liable, and the store manager doesn't get to make that decision. I mean, he may make that on the front end, he may deny the claim, but then Carlita would have the legal process and the litigation process to have that kind of explored a little bit and heard before a jury ultimately, and she would be entitled, if the jury agreed with her that the store is liable, she would be entitled to recover those medical bills and her pain and suffering and lost wages as well.
That's right. In the parlance of most lawyers, this is a slip, trip, and fall case. And actually, they all turn around knowledge. They fall into a couple of different categories. There is a patent defect and there's a latent defect. If you walk across the front porch of a house and there's a rotten board that's been painted over, to all appearances, it looks normal. You step and the board breaks and you are injured, then you might very well have a claim if the owner or occupier of the premises either knew or should have known through reasonable inspection. I believe this was a grocery store, wasn't
it? She didn't say, she just said store.
Slipped and fell in a store. Okay, it could be almost anything. It could be spillage on the floor. Like in a grocery store, we had a case one time where there had been grapes and lettuce that had been left uncleaned for a long time, and it had turned into kind of a putty-like paste. And a client of ours, who happened to be a physician himself, walked through there, his feet slipped out from under him, he fell down and broke his back. Well, that condition should have been observed by the store people and cleaned up. And it had been there for some period of time. So time is an important factor in that too. And then, you know, there's always then the open and obvious danger. If you're walking down the sidewalk and somebody left a manhole cover off of an access to the sewer system, you know, it's open and obvious, you're looking at it, you can't just walk into it and claim that it was a defect in the premises. But they're all fact intensive. It turns around the facts in each case, and Marty is completely correct. It's not up to the store manager or the insurance adjuster to decide that. It would require somebody to go out and investigate it and determine what the facts were, whether or not it was a defect that should have been taken care of by the store, and that it was something. For years and years and years, there was one case where there was a clear plastic hanger on a terrazzo floor in a clothing store. So being clear plastic, you actually just see the floor. And a fellow stepped on it and that slid out from under him. He was hurt. The Supreme Court, and in discovery on the case after the suit was filed, the defense lawyer asked the injured party, well, did you see the coat hanger? And he replied, no, I didn't see it. And this was incredible. It speaks to the difficulty sometimes in our Court of Appeals. The lawyer then asked the client, asked the injured plaintiff, if you had looked, would you have seen this clear plastic coat hanger? To which the plaintiff responded, well, yes, if I had looked, I would have seen it. But as in most stores, he's looking up at the goods they've got to sell. But our Court of Appeals, and it's not the current Court of Appeals, so I hope nobody takes issue with this. It was many years ago, and it was a historically bad decision. But the Court of Appeals then said that the trial court should kick that case out on summary judgment because the client said he could have seen it if he'd looked. Well, the law has changed since then. It still now revolves around facts, what the facts are, what is reasonable is more or less the standard now. Either the store should have known about it, or could have fixed it. The person who was injured didn't see it or wasn't aware of it, certainly didn't do it on purpose. So yeah, it's a case that would have a fact issue for a jury to determine, not a claims adjuster.